The accused blood test returned a negative reading for alcohol, but a positive reading for the following: morphine 0.0006 milligrams per litre, fentanyl 0.001 milligrams per litre, ketamine 0.07 milligrams per litre, metoclopramide 0.03 milligrams per litre, desvenlafaxine detected, venlafaxine 0.11 milligrams per litre, and mirtazapine 0.01 milligrams per litre. It was concluded that the accused was not under the influence of any drug detected in his blood during the collision. The morphine, fentanyl, ketamine, and metoclopramide are all drugs that were administered by ambulance and or hospital staff. Dr. Judith Pearl, the forensic pharmacologist who was engaged by the prosecution to provide an expert opinion on the effect on his driving of the prescription drugs in his medication, stated as follows. Her opinion is that venlafaxine, if used as prescribed, is not likely to impair one's ability to drive. However, at the start of the therapy, that is, within the first 1 or 2 weeks of use, some patients are known to experience mild sedation and drowsiness, which may contribute to impairment. Given the level of venlafaxine in the accused's blood, it was determined that it was within the therapeutic range, consistent with the accused's dosage of 150 milligrams. Therefore, it was unlikely to have had any adverse effects on the accused driving. Her opinion is that mirtazapine is an antidepressant which does have adverse side effects, including sedation, dizziness, weakness, confusion and tremor. The medication carries with it a warning label that states, quote, "This medication may cause drowsiness and may increase the effects of alcohol. If affected, do not drive a motor vehicle or operate heavy machinery," unquote. The level of mirtazapine in the accused's blood was assessed to be below the therapeutic range, which is 0.03 to 0.01 milligrams per litre. Dr. Pearl indicated that there may have been some slight impairment due to mirtazapine. However, given his low blood concentration of mirtazapine and the description of his manner of driving by witnesses, she could not form a firm opinion that there was impairment due to the mirtazapine. A report obtained by the defence from the toxicologist Dr. Michael Robertson suggested the possibility of serotonin syndrome and or drug-induced mania caused by venlafaxine. Neither Dr. Pearl nor Dr. Robertson were qualified to diagnose a drug-induced mania. Therefore, an expert report was sought by the Crown from Dr. Kerry Eagle, a forensic psychiatrist. Dr. Eagle concluded that it was not reasonably possible that the accused was affected by serotonin syndrome. The defence expert, Dr. Allnut, also a forensic psychiatrist, agreed with Dr. Eagle. However, opined, quote, "If one accepts that the accused has no memory for the alleged offence, then one must accept at the material time he experienced some disturbance in his mental state, but the nature of this disturbance is unclear," unquote. He recommended that the accused seek the opinion of a neurologist, and in particular about the presence of a temporal lobe seizure. Associate Professor Spira, engaged by the defence, obtained a history from the accused that at some stage the accused thought perhaps 2009, but that appears now to have been 2011, suffered from a seizure and was seen by a neurologist and had an EEG which was within normal limits with no focal or elliptiform features. In addition, Associate Professor Spira was informed by the accused that on one occasion, either in 2015 or 2016, he found himself lying on the ground in a neighbour's front yard about 300 metres from his home. His last memory had been being at home on his computer. His last work on the computer was 1 to 2 hours prior to his checking it later. The accused had very little recall of that incident and did not believe he sought medical treatment with regard to its occurrence. Associate Professor Spira concluded, quote, I believe that a likely scenario is that Mr. Davis suffered a complex partial seizure and was in an epileptic automatism at the time of the collision. In suggesting this, I note the two previous lapses in consciousness described in the bullet point list on page 3 above, that is, in his report. The first occurred in 2009, in fact that was 2011, and appears to have been another equivocal elliptical form conclusion. The second occurred in 2015, 2016, and from the description I obtained from Mr. Davis, this was also most likely of a similar form given the prolonged period of unconsciousness, or at least retrograde amnesia. That duration of loss of awareness means that the episode could not have represented a single syncope. Furthermore, the fact that he had walked a distance to where he regained consciousness in a neighbour's yard, some 300 metres from his home, suggests there may have been an automatism prior to the full loss of consciousness, unquote. Professor Ernest Somerville was engaged by the Crown to respond to the report of Associate Professor Spira. In particular, he was asked, question, whether, in your opinion, Mr. Davis was undergoing an episode of epileptic automatism at the time of the collision. His response was, quote, the term automatism, when used by neurologists describing seizures, is defined as, quote, a more or less coordinated motor activity, bracket, movement, close bracket, usually occurring when cognition is impaired and for which the subject is usually, bracket, but not always, close bracket, amnesic afterwards. This often resembles a voluntary movement and may consist of an inappropriate continuation of pre-ictal, bracket, pre-seizure, close bracket, motor activity, unquote. I believe this is the most likely explanation of the collision, unquote. Question. Is it possible to exclude that Mr. Davis was undergoing an episode of epileptic automatism at the time of the collision? His response, I do not believe it is possible to exclude. However, Professor Somerville's expert report is dependent on the accuracy of assumptions, including the accused's account on the day of the collision and having no memory of the collision or the prior driving. The accused's account of his medical history, where largely corroborated. He's had a long and complicated medical history since the age of about 15. The accused held an unrestricted C-class driver's licence, expiring on the 25th of October 2026. He was first licensed to drive in New South Wales on the 8th of June 2007 at age 16. He has held a licence continually in New South Wales since then, bar for some very short periods in 2016 and 2017 when his licence was suspended for fine defaults. Records retrieved by investigators from Transport New South Wales show on the 14th of September 2015 the accused completed by hand a, quote, replacement application, unquote, stating his New South Wales driver's licence had been, quote, damaged or destroyed, unquote. He signed the form. On 25 October 2016, the accused completed by hand a licence renewal application seeking a 10-year licence. In answer to question 7b, quote, do you have epilepsy? He answered, quote, no, unquote. In answer to question 8, quote, have you had attacks of giddiness, blackouts, fainting or other sudden periods of unconsciousness in the last 5 years, unquote? He answered, quote, no, unquote. In answer to question 9, quote, do you have any medical, physical or mental disabilities which might affect your driving, unquote? He answered, quote, no, unquote. He signed the form immediately below the declaration that, quote, the information on this form is true and complete. Under the road transport legislation, it is an offence for anyone to attempt to obtain or renew a driver's licence by false statement or dishonest means, unquote. Those are the agreed facts. There are matters about which there is no dispute and which I find proven to my satisfaction beyond reasonable doubt, and they are these. That on the morning of the 1st of September 2019, the accused left his home at Brunswick Heads and travelled towards Mullumbimby via the old Pacific Highway and Golgan Road before turning on to Mullumbimby Road. That the accused travelled a distance of 3.6 kilometres before anyone witnessed his manner of driving. That on the corner of Golgan Road and Mullumbimby Road, the accused motor vehicle was seen to cut the corner and to pass on the inside of a vehicle driven by Mr Gary Guy, to travel on the incorrect side of Mullumbimby Road for approximately 100 metres, and then to travel back onto the correct side of the road, avoiding an oncoming motor vehicle, before returning to the incorrect side of the road until his vehicle approached the corner near the turn-off to the fruit and vegetable store, a distance of 400 metres. That there was limited visibility at the corner near that turn-off. That on the 1st of September 2019, Peter and Anne Boland were travelling at an estimated speed of 70 kilometres per hour east on Mullumbimby Road. That it was shortly after 11:30am that morning that their vehicle was involved in a collision with the vehicle in which the accused was travelling, and sadly they died from injuries as a result of the motor vehicle collision on the Mullumbimby Road between their motor vehicle and that of the accused, Mrs Boland at the scene, and Mr Boland on the 5th of September 2019. That both victims had injuries consistent with seatbelts having been worn at the time of the collision. That the accused sustained injuries consistent with having worn a seatbelt. That the accused did not have drugs or alcohol in his system at the relevant time, which impaired his driving. That the accused alighted from his motor vehicle, walked a short distance, and then lay down on the grass where he was attended by police officers and ambulance. That the accused was not suffering from serotonin syndrome, a finding made in accordance with the opinion of the expert witnesses qualified for both the Crown and the accused. That there is no evidence of excessive speed on the part of the accused. Indeed, I find beyond reasonable doubt that the speed of the vehicle driven by the accused and the deceased was the same, namely approximately 70 kilometres per hour. That the point of impact was to the north of the eastbound lane, consistent with Mr Boland taking evasive action to avoid the collision. That the accused vehicle had moved towards the northern side of the road also, for reasons unknown. That the damage to the accused vehicle was generally on the front end with a bias towards the right front side. That the damage to Mr Boland's vehicle was generally to the right side of the front of their vehicle. That there were no mechanical defects identified on the accused's vehicle, and that the accused had suffered from a tonic-clonic seizure in 2011. The central issue in this trial is whether the Crown can prove beyond reasonable doubt that the accused was voluntarily driving his vehicle from the time he left his premises in Brunswick Heads to travel to Mullumbimby until the time of the accident. To drive a motor vehicle involves being in control of the steering, movement or propulsion of the vehicle. It is the Crown case that I would find based on the evidence of the accused contained in the written statement made by him on the 7th of February 2020. Quote, I recall leaving my house in Brunswick Heads, reversing the car back in as I forgot my sunglasses. My eyes were feeling very sensitive to the light. I cannot remember if I got my sunglasses, unquote. That I would infer that he was temporarily suspended, that I would infer he has temporarily suspended his driving in order to retrieve his sunglasses. That I would find the driving starts from the moment he got into the car that morning, notwithstanding a break in time wherein he goes back into the house to retrieve his sunglasses. The Crown submits in light of the lack of evidence of him turning off the vehicle and removing the keys before alighting from the vehicle to retrieve his sunglasses, that I would find the accused was voluntarily and consciously driving the vehicle from that point on. Relevant, of course, to the alternative counts. In the event I'm not satisfied beyond reasonable doubt that the Crown has made out its case in respects of counts 1 and 3 on the indictment. That the course of driving was not only voluntary, but was deliberate, the motive being for the accused to take his own life. the driving being so criminally negligent as to amount to manslaughter. It is, of course, for the Crown to prove beyond reasonable doubt the accused was voluntarily, consciously and deliberately driving his vehicle. In terms of the elements of counts 2 and 4, although at a glance the charges may appear that the Crown has to prove beyond reasonable doubt that the accused was driving dangerously at the time of impact, that does not mean the precise second when the cars collided. If it did mean that, then if the accused was acting involuntarily whilst in a seizure, then he could not have been driving dangerously, or indeed at all, at the time of the impact, and the Crown could never succeed. It is necessary to look at the driving at the time which is close enough to the time of his vehicle colliding with that driven by the Bolans, so that it can be said that at the time of impact the accused was driving in a manner which was dangerous to another person or persons. It is not in dispute that a person who is acting involuntarily cannot be said to be driving his or her motor vehicle. In terms of counts 2 and 4, it is necessary to look at how the accused drove before he had the seizure on the day and consider whether his driving was in a manner which was dangerous to another person or persons before the alleged seizure in a practical sense, and hence the cause of the impact and the deaths of the Boland. But I return to whether the Crown has proved its case in respect of counts 1 and 3 on the indictment. I am not satisfied that the Crown has proved to my satisfaction beyond reasonable doubt that the accused journey on the 1st of September 2019 was voluntary, conscious and deliberate, motivated by a desire to commit suicide. I reject the Crown's submission that the collision was as a result of a desire of the accused to take his own life, that his driving was so criminally negligent as to exceed that which could be categorised as driving in a manner dangerous, amounting to manslaughter. I find the overwhelming weight of the evidence which I accept is to the contrary. First and foremost, the accused gave evidence, and he denies this was an attempt at suicide. He says he was not feeling suicidal at the time. He says he did not consciously drive on the incorrect side of the road. He said in evidence, when asked, question, "Has it ever been in your contemplation, perhaps, to use your car as a vehicle in which to commit suicide?" He replied, quote, "Not at all, and the most distressing part of this has been the fact that cars are dangerous, and I cannot think of anything worse than that as a method of suicide, due to the impact it would have on others," unquote. When asked about what he meant by the, quote, "impact on others," and how he felt about that, he replied, quote, "Awful, as there's nothing I can do to change the past. I had no motivation or intention for that crash," unquote. When it was suggested to him in cross-examination that he had made prior attempts at suicide, he says he did not view his previous overdoses as attempts at suicide. When it was suggested to him in cross-examination that he was reckless as to whether his overdosing could result in suicide, he replied, quote, "No, I definitely would have cared that it happened because of the effect it would have on people around me," unquote. He had put in place a mechanism whereby if he was feeling, quote, "unsafe," unquote, not suicidal, unquote, that he could contact his brother who would come to him as had happened. He was someone who did not drive after being told by a medical professional in 2011 not to drive for at least 3 months. He says he didn't drive for 6 months thereafter. He says he did not drive if he had been binge drinking. He says he did not drive when he thought he was affected by medication he was taking for his insomnia. He was cautious to wait until he felt safe to drive, depending on the circumstances, namely not before 8 a.m. or not before 10 a.m. I find his demeanour when giving evidence on this topic demonstrated someone genuinely concerned of the impact of committing suicide would have upon others as a major concern for him, such that I am comfortable in coming to a conclusion that he was not intending to commit suicide on this occasion, or indeed on prior occasions, as the Crown would have me find. And whilst medical practitioners may well have seen his misuse of alcohol and prescription medication and or illicit substances as overdoses in an attempt at suicide, the explanation he gives is that the misuse of medication and or alcohol and or illicit substances was to resolve issues relating to his insomnia, not as a desire to end his life. I can find no good reason to doubt him. It is not in dispute that he suffered from intractable insomnia and indeed other health issues, including addictions, depression and anxiety for many, many years, for which he sought out treatment, including voluntary admission into rehabilitation facilities and mental health facilities when necessary. I find he's been open and honest with the medical profession at all times regarding his history of misuse of illicit and illicit substances and alcohol, which I find supports his credibility, and indeed I find him to have been equally open and honest when giving evidence in this court. Indeed, in many of the various medical records tendered, he's been found not to be suicidal, rather than suicidal. Other facts relevant to my finding are that he was intending to drive to the supermarket to purchase food, not something consistent with someone wishing to take their own life, that there would have been ample opportunity for him to collide with a tree on his way to Mullumbimby Road, the old Pacific Highway, and Goldgame Road being rural roads, no doubt lined with trees, rather than waiting for an opportunity to drive into the path of an oncoming vehicle. He was wearing a seatbelt, hardly something one would do if they were intending to take their own lives using a motor vehicle. He had a holiday booked to Japan about which he was excited, and he'd taken out travel insurance in the days leading up to the intended date of departure. A trip which had been planned for some months with his family. He was passionate about food, and in particular Japanese food. When giving evidence of his inability to go on that trip, he was appropriately distressed. At the time, he was seeking psychiatric treatment and was reportedly not suicidal. He did not accelerate into the first vehicle he approached. Indeed, on the evidence of independent witnesses, he managed to avoid colliding with it. The path his vehicle took on the bend was a straight path, and the collision in fact occurred off the shoulder of the road. He would not have been able to see the deceased's vehicle to deliberately drive into it in his path. He was not driving at an excessive speed, accelerating into the path of the oncoming vehicle, and whilst Mr. Guy says he observed the accused vehicle to be accelerating, it is not known whether that was at an excessive rate. What is known is that the vehicles collided doing approximately the same speed, namely 70 kilometres per hour, not consistent with someone accelerating at such a speed, consciously attempting to collide with another vehicle in order to commit suicide. When spoken to on the 9th of September 2019, and the topic was raised with him by hospital staff, it was reported as follows, quote, adamantly denied that he would intentionally have driven in a way to put himself or anyone else in danger. He said he is, quote, not like that, unquote, and although he does not remember, knows this would not have been the case, unquote. In the opinion of Dr. Spira, he dismisses that this was a suicide attempt. He regarded the accused as someone who gave him a credible history. He, of course, had the advantage over Professor Somerville, who did not assess the accused. The evidence as to whether the driving was voluntary relies on the evidence of the accused and the opinions of the experts based upon his version of events. There are mildly inconsistent versions as to his recollection of his last memory. The Crown relies upon the version contained in the statement provided by the accused to police. It was not a statement made on oath, and it was a statement made in circumstances wherein I find it to be less reliable.
Did it froze? Yes, it's frozen. Everyone says frozen?
I find the most likely scenario for the cause of this collision was that the accused suffered from a complex partial seizure and was in a state of epileptic automatism from the time he left the house after seeking to retrieve his sunglasses until the time he regained awareness, some 15 minutes or so after the accident. And I will come to my reasons for making those findings shortly. Criminal responsibility does not attach to an act done in a state of automatism. That is, where an act is not done in consciousness of the nature of the act and an exercise of a choice to do an act of that nature. I remind myself that it is for the Crown to prove beyond reasonable doubt that the driving of the accused was willed and voluntary and not the result of a condition of automatism. As I've said, I find myself satisfied that the driving was as a result of a condition of automatism, and therefore the Crown has failed to prove to my satisfaction beyond reasonable doubt that the driving was willed and voluntary. I base this finding on the evidence of Professor Somerville and Professor Spira. Their opinions are largely in agreement, although there are some minor areas of disagreement which I find are of no moment. Dr. Spira is of the opinion, quote, that a likely scenario is that Mr. Davis suffered a complex partial seizure and was in an epileptic automatism at the time of the collision, that there is sufficient index of suspicion that an epileptic automatism may be responsible, unquote. Both experts agree that it is possible for a person in an episode of complex partial seizure to appear conscious, although somewhat detached and somewhat not responsible, to retain an ability to manipulate objects, to drive, and to complete activity which appear to be semi-purposeful. Both experts give examples in their reports of patients performing even complex tasks within a seizure, such as driving a motor vehicle without adequate alertness or. In the report of Professor Somerville, he states, quote, it is possible for a person experiencing a seizure to control a vehicle to a varying degree to be involved in a crash and have no recollection of it afterwards. In the opinion of Professor Somerville, quote, if the behaviour was involuntary, then the occurrence of a seizure is the leading possibility, unquote. He stated, quote, I believe that a seizure is the most likely explanation of the collision, unquote. In his opinion, a focal impaired awareness seizure, an opinion which he does not believe is possible. It is his opinion that the accused was in a focal impaired awareness seizure, an opinion which he does not believe is possible to exclude. Professor Somerville states that the accused was, quote, transiently confused after the crash. Transient confusion usually follows focal impaired awareness seizures, unquote. But the accused also had other indicators of having suffered from a focal impaired awareness seizure, including evidence of diaphoretic sweating. The opinions, of course, are not based entirely on the history given by the accused of a loss of memory of the entire incident, but are also based on the observations of others who were present at the scene, and indeed the history of past episodes or incidents which are considered likely to have been seizures. Witnesses who refer to him as being dazed and confused and appearing to be in a state of shock. The attending ambulance officers described him as confused, and there being a reference to retrograde amnesia, something which has been discounted by the experts as there's no evidence of any form of traumatic brain injury which would be necessary for there to be a retrograde amnesia. The Crown says I would not accept the evidence of the accused to be reliable as to some important matters, and refers to his disagreement with the opinions of what is contained in the records of the various institutions where he has attended and or what is contained in reports tendered in evidence. The accused does challenge the accuracy of some of the histories recorded in the medical records, and I find does so with good reason. One glaring such example, not alluded to by either counsel, is the history contained on the 2nd of February 2019 in the Gold Coast Hospital records, which is entirely at odds with all of the other evidence. It states, quote, remembers most of the incident. High speed front on MVA, hit head, unquote. Nowhere is there evidence of the accused remembering most of this incident, nor is there evidence of a high-speed front-on MVA, and nor is there any evidence, including from a brain scan, that the accused hit his head. Indeed, Associate Professor Spira is critical of the treatment of the accused immediately following the accident. He says, in his view, the examination of him at the time was incomplete, and not all possibilities were considered or investigated adequately. I say no more. The accused says he does not recall giving a history to Mona Vale Hospital that he experienced a seizure in Thailand. It's not a history he could have given to the ambulance officers, as there was certainly no dispute that he was unconscious when he was transferred to hospital. Of course, it would be to his advantage if there had been an earlier episode, which would have added to the total number of seizures and increased the likelihood of a diagnosis of epilepsy. Of course, no such diagnosis has been made. The Crown challenges the reliability of the accused's account of an incident occurring in 2015. Once again, I have no reason to doubt the reliability of the accused's account of such an incident having happened. Indeed, if the Thailand incident, which is denied by the accused, and the 2015 incident are excluded, there is still objective evidence of a seizure in 2011 sufficient to enable the opinions of the experts to be soundly based, having regard to the objective evidence associated with the accused's symptoms and loss of memory, if that is accepted, following this incident. The Crown also relies upon the inaccuracy of the completion of the RTA records in 2015 and 2016 regarding his seizures as something which undermines his credibility. The accused says he cannot now recall what was in his mind when he was completing that form back in 2016. Clearly, if the event of 2011, which he mistakenly thought was 2009, was within his recall as having occurred in 2009, then that would have been outside the 5-year period in any event. If he had been aware that it was 2011, it was still outside the relevant period. He, of course, would not be the first person to incorrectly complete such a form. It's not unknown for drivers to attempt to complete a form indicating, for example, that they do not wear glasses and yet fail the eye test. He would not be the first person to have not read a declaration before signing it. He was still a relatively young man. It was not suggested that, in fact, the accused lied in terms of completing the form. He denies falsely completing the form so as to ensure that his licence was replaced and or renewed, as there was a need for his licence. He says, indeed, at times there was no need for a licence, such as when he and his brother were both working in the Byron industrial estate and his brother drove them to work. Since the accident, he has not driven and he's managed. There have been other times when he's chosen voluntarily not to drive, maybe needing to, perhaps only 1 or 2 days per week. I carefully watched the accused in the witness box. I carefully listened to his evidence. The Crown says he was not willing to make appropriate concessions. With respect, I do not agree with that submission. There were many, many aspects of his evidence which supported his credibility. As I've already stated, he made disclosures to medical practitioners about matters about which he could have easily have failed to make full and frank disclosure, such as his source of obtaining opioids and benzodiazepines which were not prescribed for him. He was open and honest about mixing medications and alcohol and, to occasions, on excess. He was open and honest about his use of cannabis before it was legally prescribed to him. The relevance of finding him a reliable witness is, of course, that the experts base their opinions regarding his history of seizures upon his evidence, apart from the Mona Vale Hospital record regarding the seizure in 2011. There's no independent objective evidence of the incident which he says occurred in perhaps 2015 or 2016, which both neurological experts consider likely to be a seizure, and support their conclusions that the likely...
Froze again.
Press it here.
Reload the page. See the little reload thing?
Here.
Circle goes around. In the corner. We'll just reconnect. See if that works.
Did we
diazepine withdrawal. Associate Professor Spira does not necessarily agree with that diagnosis. Professor Somerville does not agree nor disagree with either, but proffers a different opinion based on experience and articles. What is not in dispute is that what is not in dispute is that in 2011, what he had, whatever be the etiology, it was ultimately a tonic-clonic seizure. The relevance of what might have precipitated that seizure is the nature of the seizure which is said to have been the likely cause of this accident, and that is a focal impaired awareness seizure. Whilst the 2011 seizure is said to be tonic-clonic, there were features which Professor Somerville thought might indicate that there was a focal impaired awareness seizure which preceded the convulsive seizure, which was noted by the accused friend, resulting in him being taken to hospital by ambulance. And that primarily is the evidence that on that occasion and on this occasion there was evidence of extreme sweating. Normally seizures tend to be of the same type, however, as it is not known whether there was a focal impaired awareness seizure precipitating the 2011 seizure. In the opinion of Professor Somerville, the experts would have to keep an open mind about their final diagnosis. That I find tends to support their conclusions as to the nature of the seizure which the accused suffered on this day, and that was that the accused suffered a focal impaired awareness seizure, which is also known as a complex partial seizure. Professor Somerville, when questioned about the likelihood of the seizure being for the duration of the time from when the accused left Brunswick Heads until the conclusion, says it's unlikely but not impossible. Seizures last normally about a minute, maybe a couple of minutes. This seizure, if the lack of memory extends over that entire period, could have lasted significantly longer than normal. In the opinion of Associate Professor Spira, a seizure commences when there is something akin to a switch being thrown in the brain, and as a result, a patient suffers from epileptic amnesia. Transient epileptic amnesia explains the loss for the duration of the seizure. The glare which the accused noticed when leaving the house initially may well have been the commencement of the seizure. Neither expert excludes the possibility that the seizure commenced from the time the accused left the house, which would have the effect of the seizure extending for a longer period of time than would have been anticipated, but not outside the realms of possibility. In light of all of those pieces of evidence, I find the accused not guilty of counts 1 and 3 on the indictment on the basis that the Crown has not proved that the driving was voluntary, conscious and deliberate as alleged. I turn to counts 2 and 4 for the sake of completeness, although in light of my finding that the Crown has failed to prove he was driving voluntarily from the time he left his premises until the time of the accident, it is unnecessary to do so. I find, on the evidence of the accused given in this court, that he has no memory from the time he entered the house to try and find his glasses. His statement made at the time, whilst he was in hospital, upon which the Crown relies, whilst undergoing treatment, suffering trauma, commenced while he was in hospital in Queensland, but it would appear that it was not ultimately signed, perhaps until he had been transferred back to New South Wales. It's in that statement he could recall leaving the house, reversing his car out and then back in, but then goes on to state, quote, "I cannot remember if I got my sunglasses," unquote. And that's consistent with his evidence before me, that he has no memory from the time he entered the house in order to try and find his sunglasses. It's also consistent with the evidence, Dr. Allnut, who also had a consultation with the accused, that he, quote, "could not recall leaving the house," unquote. But if I'm incorrect in that regard, and he was in fact driving voluntarily as submitted by the Crown, I find the Crown has failed to prove beyond reasonable doubt that the accused did not believe on reasonable grounds that it was safe for him to drive. The question as to whether the accused was driving dangerously when he was voluntarily driving shortly before he reached the intersection where he was first seen to drive, as described by Mr. Guy on the Crown case, is an objective test. It does not matter when considering this test whether the accused believed it was dangerous for him to drive or not. His subjective thoughts as to such things as the likelihood he would suffer a seizure whilst driving are irrelevant. The issue I have to decide is whether, when he voluntarily drove, as alleged, from Brunswick Heads until the intersection of Golgan and Mullumbimby Road, it was dangerous for him to do so as a result of the likelihood he might suffer a seizure. The mere fact of him driving in that condition would constitute driving in a manner dangerous, because driving in that condition could subject another person or persons to real significant and substantial risk of injury or death over and above that ordinarily associated with the driving of a motor vehicle. It is the Crown case that there was an increased risk of the accused having a motor vehicle collision because of the risk that he might suffer a seizure. There is, of course, no evidence that at the time the accused drove he had been diagnosed with epilepsy or the likelihood that he might suffer a seizure whilst driving. It is for the Crown to prove beyond reasonable doubt that the accused suffered from a condition which made the mere fact of his driving a real danger to the public, that he was driving in those circumstances, and if that is proved beyond reasonable doubt, there was no reasonable grounds for him to believe that he was safe to drive. As I've already found, the driving from Brunswick End to the point of collision was not voluntary. However, as I've said, if I'm wrong, and the accused did reverse the car out of the property, reverse back in, and then drive off, as the Crown submits, the Crown was able to prove that the accused suffered from a condition which made him a danger to the public, then it would be open to find the element of dangerous driving made out. There is, of course, no definitive diagnosis by anyone, including the two forensic neurologists engaged for the purpose of determining this issue, that the accused suffered from epilepsy. The evidence is that in 2011 he likely suffered a seizure as a result of benzodiazepine withdrawal. He was not given a diagnosis other than that and warned about the risk of misusing diazepines. He accepted the doctor's advice to a certain extent in that he remained off the road for some time, but of course he continued to misuse benzodiazepines on occasions which did not result in further seizures. In 2015 he was not abusing benzodiazepines when he had the episode he put down to being related to insomnia. So there was nothing between 2011 and 2015 of a like nature. And there was nothing after 2015 until the day of the accident of a like nature either. There had been no contraindications by way of seizures whilst driving previously. It was reasonable, I find, in those circumstances for him to honestly believe that it was safe for him to drive a vehicle and to do so. At the risk of being over-repetitious when considering what the accused actually believed, I must ignore anything which the accused did not know. He thought he was safe to drive. He says if he had not considered himself safe to drive, he would not have done so. And I find his evidence in that regard to be reliable. I find his evidence that he did not link the 2015 episode to the earlier seizure also to be reliable. I find that the episode did not come to his mind until it was prompted by the questions asked by Dr. Spira. I find that he did not deliberately set out to deceive the RTA in 2015 or 2016 when he completed the forms about which he had been extensively cross-examined. I find he did not turn his mind to the 2011 or 2015 episodes when answering the questions contained in the forms, particularly in 2016. As was suggested in Jimenez and the Queen, 1992, 173 Commonwealth Law Reports, 572 at 583, an inference can be drawn that a person believed that it was safe to drive from the very fact that he was driving. I find this to be an appropriate case to draw such an inference, and I do so. The very fact that the accused was driving would suggest his belief as to the lack of dangerousness of his conduct. After all, one of the persons put at risk by the accused driving was himself. The best evidence of the accused's belief can be found in the completion of the documents in 2017 when he was applying for his 10-year licence. The accused was not afraid that his licence might not be renewed or that he might be subjected to further investigation by the RTA. As he says, for the benefit of hindsight, he wished he had drawn the attention to medical practitioners of the incident in 2015, and if it had been investigated, the situation he now finds himself in, having been involved in an accident resulting in the unfortunate death of two people, might have been prevented. I am not satisfied beyond reasonable doubt. The Crown has proved that the accused did not believe it was safe for him to drive. In light of the lack of objective evidence, I find it was entirely reasonable for him to drive. He was appropriately medicated for his insomnia and depression. He had not been diagnosed with epilepsy, nor medicated for any other condition, nor had he been told he was at risk of further seizures. I find he was seeking appropriate treatment for his insomnia and related medical health reasons. I find the Crown has failed to discharge the onus of proving that he did not believe on reasonable grounds that it was safe for him to drive. And I find the accused not guilty of the alternative counts on the indictment. Would you please stand? Please stand. I find you not guilty of the 4 counts contained in the indictment. Thank you. Members of the family, I know these cases are tragic. There are never any winners. The court extends to you its sympathy in respect of the loss of your elderly family members. Now, are there backup charges to be dealt with?
Based on your own finding.
All right, the backup charges are withdrawn and dismissed.
Well, some backup, some related on the 166,
Oh.
all should be withdrawn.
All are to be withdrawn and dismissed. Anything arising?
No.
Anything arising? I'll go off, thank you.
Take a seat, have a bit of a breathe out, and we can have a debriefing in the room.
Did you see his face, Anna?
No.
No.
Oh, but they're ready to proceed.
Well, supposedly.
Okay. Well, that's interesting. Okay.
Am I still updating the Yes.
Yes.
Okay.
Have you?
Not yet. No, not yet.
No, that's okay. Well, I'll update for
Still.
these ones, and
Oh, do you want to do
I'll update
those?
for these ones.